The GDPR has to fulfill the requirement of technology neutrality. This is in principle a good requirement because it makes possible that the GDPR can be applied not only for 1 year or 5 years, but for several decades perhaps, and can be valid, which means that the GDPR is quite abstract. So almost everybody reading an article in the GDPR does not exactly know what to do now. So how to specify the next steps for your data processing, what is really necessary, or how should it be interpreted. Okay, this translation will be provided by many players, among others the supervisory authorities. Still, the technology neutrality is in principle a good thing. On the other hand, we will have the disadvantage to renegotiate everything which we negotiated in the past. So we relied on national law, perhaps on European law, and negotiated good solutions. In principle, this is now an open discussion because of the abstract wording in the GDPR. This may mean that everything has to be re-evaluated. Is it, for example, necessary for a mobile device that the data there is encrypted? This is a Schleswig-Holstein law for the public service. If it's mobile, the data has to be encrypted. But is it really necessary? Is it because of the risk? And now it has to be re-evaluated, and perhaps some people will challenge these findings, which are quite valid for us anyhow. On the other hand, we see that the technology neutrality is not really neutral. It means that we probably see many assumptions of the GDPR and of all the legal texts that they focus especially on central entities like the data controller. So the data controller should be the trustworthy one, should prove that the data controller is compliant, but then in principle it's okay that this central role is being fulfilled. This also means that those users who don't want to trust or still have some uneasy feelings, that they may want to use extra tools, self-defense, self-data protection tools to really protect their data. They may trust the data controller, still they want more protection. And so who is now responsible of providing data protection tools to users? Perhaps not the controller, because the controller has proven that the data is safe enough. But we argue that at least it should be possible that the interfaces for data protection tools on the user side should be provided. Like, for example, if a person decides to surf anonymously the internet, to use some browsers, some anonymizing proxies, and these accesses may not be blocked because this is outside the responsibility of the data controller. Still, the data controller could decide to interfere with the protection level the user wants to have. Another thing is that users may want to use some crowd or peer-to-peer solutions. Are they now data controllers, each individual? Well, we could argue that this is now possible if there's potentially personal related data. On the other hand, does it make sense to put the burden on each individual to really comply with everything which is in the GDPR? These are open issues. Because if there's a high risk, then of course, on high risk for personal data of other people, then of course I'd like to see some precautions and protection means. But what is the bureaucracy behind? They are doing it for their own purposes, and of course there's an exemption in the data protection regulation as it has been before. Still, the power each individual with the normal equipment now has in data processing is much more than we had before. And this will probably even increase, that each person can be part of a surveillance system. So we have data protection and privacy by design technology that makes use of many individuals. We also have surveillance technology that also profit from many individuals. And this means how to balance this. The data protection regulation does not really address it. And there are other parts where also the question of what should be centralized and what can be decentralized or is even better in a decentralized way are not really well debated now, and this means that there might be some other legal regulatory approaches to also cover those additional topics which maybe become now more visible. This can be in countries where people are not allowed the right to free speech and have to protect themselves. It can be with data protection, self-protection and self-defense tools. So the privacy by design discipline offers many of those tools which are not directly addressed here in the GDPR. And another thing which is also interesting is about linkage. The unlinking the data, unlinkability by the data controller is rarely found in practice right now, and it's also not so much demanded in the GDPR. Okay, there are some data minimizing tools or the principle of data minimization. Still, should the data controller be obliged to separate the data and to put in other entities only for the purpose that the data controller has not access to the own databases? We see some contexts and some scenarios where this makes perfectly sense, and that also the trust in the data controller can rise. And of course, with biobanks, with genetic data, with blood samples, it's a good tradition already to have separated entities and really defined data transmission rules, so that it's clear that not one entity has access to everything. Still, this is something where the GDPR usually assumes the central data controller who has to prove that the provisions of the GDPR are fulfilled. And now we see, not only on the horizon because it's already existent, much more challenges from the IoT field. So all devices can communicate with each other, or with algorithms where the fairness debate has now started, which is a good thing. Of course, the fairness is something from the European GDPR in the principles in Article 5. And also, this is something where the risks, for example, discrimination risks, have to be mitigated, have to be prevented. Still, this is something which is not only related to personal data or to something where the GDPR and the data protection supervisory authorities are already equipped with. We see some quite simple algorithms on evaluating creditworthiness. But this is already very, very difficult to evaluate whether this is fair or not, and where the different sources of error, of biases may lie in. So this is something where I assume that the GDPR has only some first steps, for example, the right to access, also the logic of what is there, so the algorithms, but still we will have to discuss how much does it mean? Is it really understandable? What about trade secrets? And that we need more research, more discussion, more multidisciplinary debates to really go on. And this means the GDPR is a step ahead. Still, it won't be the only guiding law for the next decades, because there are several other things that are not directly addressed right now.